what is money laundering and what makes somebody's a person guilty of money laundering. So for that to understand, we need to know the Anti-Money Laundering Act 2010 amended till 2016. So what is money laundering? So according to section 1, a person shall be guilty of offense of money laundering if the person acquires, converts, possesses, uses or transfers property knowing or having reason to believe that such property is proceeds of crime. Secondly, a person shall be guilty of offense of money laundering if the person conceals or disguises the true nature, origin, location, disposition, movement or ownership of property, knowing or having reason to believe that such property is proceeds of crime. A person shall be guilty of offense of money laundering if the same one holds or possesses on behalf of any other person any property knowing or having reason to believe that such property is proceeds of crime, or a person shall be guilty of offense of money laundering if he participates in, associates, conspires to commit, attempt to commit, aids, abets, facilitate or counsels the commission of the acts specified in the different classes of the said act, which is Anti-Money Laundering Act 2010. Further, if we comes to the other point of what is the punishment for the money laundering, so whoever commits the offense of money laundering shall be punishable with rigorous imprisonment for a term which shall not be less than the 1 year but may extend to 10 years, and shall also be liable to fine which may extend to 1 million rupees, and shall also be liable to forfeiture of property involved in money laundering or property of corresponding value, provided that the aforesaid fine may extend it, which I narrated, that can be a 1 million or 2 million. So provided that the aforesaid fine may extend to 5 million rupees in case of a company, and every director, officer or employee of the company found guilty under this section shall also be punishable under the sections of the Anti-Money Laundering Act. So there is a National Executive Committee to combat money laundering. What is that? What is National Executive Committee? National Executive Committee, which shall consist of the following members, if it forms now or whenever or existed. They are the Ministry of Finances or Minister of Finance or advisor to the Chairman, Minister of Finance or concerned Minister, Minister of Foreign Affairs, members, Minister of Law and Justice members, Minister of Interior member, Governor, State Bank, he was also member, Chairman SECP, he is also member, and Director General member, he is also member. Any other member to be nominated by the federal government. So Minister of Finance or advisor to the Prime Minister shall be the chairman of this NEC, which is called the National Executive Committee. Responsibilities and duties of the National Executive Committees. The Director General, FMU. FMU is another unit which is called Financial Monitoring Unit, shall also act as Secretary of the National Executive Committee. Develop, review and oversee the implementation of national strategy to fight money laundering and financing of terrorism. Determine offences existing in Pakistan that may be considered to predict offences for the purpose of this Act. Provide guidance and sanction and in framing of rules and regulations under this Act to the federal government for effective implementation of this Act and framing of national policy to combat money laundering and financing of terrorism. National Executive Committee issue necessary directions to the agencies involved in the implementation and administration of this Act, which is Anti-Money Laundering Act. National Executive Committee discuss any other issue of national importance relating to money laundering and financing of terrorism and undertake and perform such other functions as assigned to it by federal government relating to money laundering and financing of terrorism. FMU, Financial Monitoring Unit, shall exercise the many power and perform many functions which are directly linked to the act of anti-money laundering. The FMU shall receive suspicious transaction reports and CTRs from financial institutions and such non-financial business and performance. FMU to receive suspicious transaction reports and CTRs from financial institution and such non-financial businesses and professions as may be necessary to accomplish the object of the act of anti-terrorism, act of anti-money laundering. To analyze the suspicious transaction reports and CTRs, and in that respect, the FMUs may call for record and information from any agency or person in Pakistan related to the transaction in question. All such agencies or person shall be required to promptly provide the requested or required information. FMU to disseminate on a confidential basis after analyzing the suspicious transaction reports and CTRs and other record necessary informations or materials to the concerned investigating or prosecuting agencies for inquiry or other action under this Act or any other applicable law. FMU to create and maintain a database of all suspicious transaction reports and CTRs related to information and such other material as the Director General determines are relevant to the work of the FMU, and in that respect the FMU is authorized to establish necessary analytics software and computer equipment to effectively search the database, source and retrieve information, and perform real-time linkages with databases of other agencies both in and outside Pakistan as may be required from time to time. FMU to cooperate with financial intelligence units in other countries and to make reciprocal. FMU to cooperate with financial intelligence units in other countries and to make reciprocal arrangements after due administrative process to share, request and receive information relating to money laundering and financing of terrorism. FMU to represent Pakistan at all international and regional organizations and groupings of financial intelligence units and other international groups and forums which address the offense of money laundering and other related matters. FMU to submit to the General Committee and the National Executive Committee the reports, including an annual report containing overall analysis of suspicious transactions reports and CTR's currency transaction reports. So CTRs, basically that is the currency transaction reports, the statistics concerning the investigations and prosecutions conducted in relation to the offences of money laundering and financing of terrorism in Pakistan, and recommendations on countermeasures to combat money laundering and financing of terrorism. So any government agency, autonomous body, regulatory authority, domestic or foreign, may share intelligence or report their suspicions within the meaning of suspicious transaction reports or CTRs to FMU in normal course of their business, and the protection provided under Section 12 shall be available to such agency, body or authority. FMU management of forfeited properties. The federal government may by order publish in the official gazette appoint as many trustees and receivers as it thinks fit to perform the function of an administrator. And what they will do, they will do the management of forfeited property. So this is the prescription of financial management of financial monitoring unit. Search and seizures. The investigation officer, on the basis of information in his possession, has reason to believe that any person has committed any act which constitute money laundering, or in his possession of any property involved in money laundering, or is in possession of any record which may be useful for or relevant to proceedings under this act. He may, under this act means Anti-Money Laundering Act, that he may either himself or authorize any officer subordinate to him to enter and search any building, place, vessels, vehicle or aircraft where he has reason to suspect that such record or properties are kept. Break open the lock of any door, box, locker, safe, almirah, or other receptacles for exercising the powers conferred by Clause 1.1, where the keys thereof are not available. Seize any such record or property found as a result of such search. Place marks of identification on such record, or make or cause to be made extract or copies of their form. Make a note of any inventory of such record or property, or examine any person who is found to be in possession or control of any such record or property in respect of all matters relevant for the purposes of any investigation under this Act. And which means this Act means Anti-Money Laundering Act. Search and seizures. If an investigation officer has reason to believe, the reason for such belief to be recorded in writing also, that any person has secreted about the person or anything under his possession, ownership or control, any record or property which may be useful for or relevant to any proceedings under Anti-Money Laundering Act, he may search that person and seize such record or property which may be useful for or relevant to any proceedings under Anti-Money Laundering Act. The investigating officer shall within 48 hours, this is 48 hours, which means 2 days, Immediately after, search and seizure forward a copy of the report on search and seizure to the head of the concerned investigating or prosecuting agency in a sealed envelope. As far as the power to arrest is concerned, if the investigating officer or any other officer of the agency referred to in this act, in Anti-Money Laundering Act, basically, is authorized in this behalf of the federal government or by general or special order, has on the basis material in his position, on the basis of the material in his position, reason to believe, the reason for such belief to be recorded in writing, that any person has been guilty of an offence punishable under this act, he may, after obtaining warrant from the court or the nearest judicial magistrate, arrest such person and shall, as soon as may be, inform him of the grounds for such arrest. Every person arrested under this clause shall within 24 hours be taken to a judicial magistrate having jurisdiction, provided that the period of 24 hours shall exclude the time necessary for the journey from the place to one place to another place or place of arrest to the magistrate court. So retention of the property, section 17 of the Anti-Money Laundering Act basically addresses the retention of the property. So it says that where any property has been seized under section 14 or section 15 and the investigating officer has, on the basis of material in his possession, reason to believe that such property is required to be retained for the purpose of investigation under section 9 or another section, such property may be retained for a period not exceeding 90 days from the time such property was seized, provided that the investigating officer shall duly inform the court about any peculiar nature of the seized property and, where necessary, seek appropriate directions from its proper care during retention. As far as retention of record is concerned, section 18 of Anti-Money Laundering law says that where any record has been seized under section 14 or section 15 and the investigation officer has reason to believe that any of such records are required to be retained for an investigation under this act, he may retain such records for a period not exceeding 90 days from the time the record was seized. The person from whom records were seized shall be entitled to obtain copies of records retained under subsection 1. As far as jurisdiction is concerned, the Code of Sessions established under the Code of Criminal Procedure 1898, Volume 5 of 1898, shall within its territorial jurisdiction exercise jurisdiction to try and adjudicate the offences under this act, and shall matters provided in, related to or arising from this act, which is Anti-Money Laundering Act, of offences to be non-cognizable and non-bailable. Number 1, every offence punishable under this act shall be non-cognizable and non-bailable. Number 2, no person accused of an offence punishable under this act, which is Anti-Money Laundering Act, for a term of imprisonment of more than 3 years shall be released on bail or on his own bond, unless the police prosecutor has been given due notice, and where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offences and that he is not likely to commit any offence while on bail. He can grant the bail. of the concerned accused. So this was a lecture regarding the Anti-Money Laundering Act 2010 as amended 2016.